Good morning. Today let us start with the third session related to the Maharashtra Cooperative Societies Act. In the first session we have discussed about the overview of the act and what is the role of a registrar. Then we have taken to the second session related to the membership, especially section 22 and 23 of the MCS Act. Section 22 talks about who can be the members and what are the conditions to become a member. Then we have also seen the application is made to the society, and if the society does not act on that within a specific period, that is within 3 months from the date of making an application, they are deemed to be the member. Then we have also seen section 23 where a person can, the membership is open to everybody, that is irrespective of caste, creed and religion, and once you apply for the membership and if it is not accepted by the society, application itself is not accepted, then of course we can go to the registrar and ask him to get it forwarded to the registrar, from the registrar to the society. And if the society, from the date of forwarding it, within 60 days, if the society does not take the action, naturally again it is considered to be the deemed member. Then of course the appeal lies under section 23 subsection 2 before the registrar. So that is what we have discussed and understood. Now let us go to the next session, section 23 to up to 25, 25A, and if required up to 35, which is regarding the removal of the members. So now let us talk about section 24. Section 24 talks about what type of members can be there. Notwithstanding anything contained in section 22, that is under section 22 we are only talking about members. Now section 24 talks about a society may admit any person as a nominal or associate member. Of course, for a cooperative housing society there is a separate chapter, chapter 13B, where a member, 4 types of members have been discussed. I am not on that today. We are only talking about a general type of society, or other than a housing society there can be nominal member and associate member in addition to the membership. So notwithstanding contained in section 22, a society may admit any person as a nominal or associate member. Now the next it talks about whether in a housing society there is a nominal member. The answer is no. As per 9th March 2019 onwards, a new chapter has been admitted where nominal member has been removed from the housing society, but their associate member has been included and joint member also has been included and a provisional member. So let us go to the next. Subsection 2 of section 24 says, a nominal member shall not be entitled to any share in the form whatsoever in the profits or assets of the society as such member. That means as far as a nominal member is concerned, he is admitted only for the namesake and he does not get anything in the profits of or the assets of the society. That means he does not have an interest in the capital of the society. A nominal member shall ordinarily not to have any of the privileges and rights of the member, but such member or an associate member may, subject to the provision of subsection 8 of section 27. Section 27 subsection 8 talks about rights and the privileges of a, of course, associate member, and section 27 is talking about voting rights of the member. So, but such member or an associate member may, subject to the provisions of subsection 8 of section 27, shall have such privileges and rights and subject to such liabilities of the member as may be specified in the bylaws of the society. That means what we are saying is the subsection 27, subsection 8 of section 27, whatever the voting rights are given, that is there with the associate member. Secondly, the rights and privileges or the liabilities of the nominal member and the associate member will be specified in the bylaws of the society. So the bylaws of the society will definitely indicate as to what are their rights and liabilities as far as associate member and nominal members are concerned. Now let us proceed. Now section 24A is a new section which was inserted after the 97th constitutional amendment, and here 24A talks about cooperative education and training to the members. See, one of the principles of cooperative is to education and training. Now, under the education and training, section 24A says, every society shall organize cooperative education and training for its members, officers means office bearers, and employees through such state federal societies or the state apex training institute as the state government may by notification in the official gazette specify such education and training shall. What such education and training will have, that is given later. So here we are saying every society shall, the word used is shall. Now organize cooperative education and training to its members, officers and employees through the state federal societies, that means state federations, or the state apex training institute. There are state federations for which there has to be government notification. So that means unless until either a state federation or apex training institute is notified by the state government in the official gazette, they cannot undertake the training as specified under section 24A. Now such training and education shall ensure the effective and active participation of the members in the management of the society. Now how this is more relevant when we discuss, because this is one of the compliance which a housing society or a cooperative society requires to do. Now no doubt for cooperative education and training, housing society separate chapter is there, we will discuss there, but all other societies, one of the compliance is they have to undergo the training, and if they are not undergoing the training, that means there is non-compliance. So because there is a non-compliance, that means the administrative action can be taken by the registrar. When we want to complain to the society or complain to the registrar against the management of the society, this can be one of the items in our complaint, saying that the society is not managed properly, they are not taking up the mandatory training which is required under the Act. Secondly, ensure the effective and active participation of the members in the management of the society. Ensure the effective and active participation of the members in the management of the society. In the management of the society, active participation has to be seen. Groom talented employees for the leadership position, that means training to the employees. Develop professional skills through the cooperative education and training. So these are the subsection 1 of section 24A. Then every member of the committee, whether elected or not, elected or co-opted, shall undergo such cooperative education and training for such period and at such intervals as may be prescribed. The moment the word prescribed comes, that means it is given in the rules. That means even the committee members have to undergo the training. Then comes every society shall contribute annually towards the education and training fund of the state federal societies or the state apex training institute notified under subsection 1 at such rate as may be prescribed. Now the question comes, as may be prescribed, it should be again given in the rules, and different rates may be prescribed for different societies or class of societies. That means every training institute, the society should contribute towards the education and training fund, which will go to the either a federal society or to the training institute which is notified by the government at such rate as may be prescribed, that means given in the rules. Now let us come to the section 25A, which is talking about, see, there are again in the case of a membership, we have again one admission of a member, as we were discussing that in the membership we have one admission of a member which is under section 22 and 23. Now again when we relate it to admission, if that is not admitted, then we have deemed member, that also we have seen, and after the deemed membership, that means if the membership is not rejected, then there is called deemed membership, and deemed membership is decided or appealed under section, so admission under section 22-23, deemed membership under section again 22-2 or 22-23-2 is the appeal, 23-1A is the deemed member, correct? Now 23-2 is the appeal sections where we can make an appeal to the deputy registrar. Now this is all about membership, all we are talking about admission. Now having admitted the membership, now the next question arises, can a member be removed? And when we talk about membership, so again there are three things which are given in the Act. One is cessation of a member, second removal of member, and third is expulsion of a member. So if you look at all these, they look more or less similar. One, we are talking about cessation of a member, second removal of a member, and third is expulsion of a member. You may say removal and expulsion, what is the difference? Yes, there are difference. Now what is that difference? And there is a difference between cessation, because when we talk about membership, this also need to be looked into, because in a cooperative society, the membership is very important aspect. So let us look at the cessation of membership. Okay, a person shall be ceased to be a member of a society on his registration from the membership thereof being, a person shall cease to be a member of a society on his resignation from the membership thereof being accepted. So that when he becomes, so that means person, the way he has become a member, he can also apply to resign. He can apply to the society and resign from the membership. So a person shall cease to be the member of a society on his resignation from the membership thereof being accepted. So once you resign, again there is a time frame. So within a particular time it has to be accepted, or it is deemed to be accepted. His resignation is deemed to have been accepted. We will see that little later. But person shall cease to be a member of a society on his resignation from the membership there being accepted by, of course, the managing committee, or on the transfer of whole of his share or interest in the society to another member. That means even if he transfers his share to a new person, then again he ceased to be the member, or on his death. So even if a person dies, that means he ceased to be the member, or removal of the membership, or expulsion from the society. So even when he is expelled or when he is removed, again he ceased to be the member, or where a firm, company or other corporate body, society or trust is member on its dissolution or ceasing to exist. That means if a corporate body is there, let us say company which is liquidated, in that case again they are ceased to be the member of the society. So this way cessation of membership has so many aspects. One is resign, which is accepted. Second is we are talking about transfer. Third is on death. Fourth is removal. Fifth is expulsion. And sixth is where the firm or a company is getting liquidated or ceased to be existed, or it is dissolved. So these are the situations where the member is considered to be ceased to be the member. So therefore, when we talk about election, when we talk about voting rights, because in the election also we look at the voter list. So if somebody's name is appearing in the final list of voters and somebody comes with the death certificate, then that means you have to say that yes, he is already ceased to be the member and therefore voting cannot be given. So these are the various instances which we need to look into. Now section 25A, which was later on added, removal of the names of the member from the membership register. See, this removal is an action which is initiated by the society. Expulsion, of course, initiated by the society but approved by the registrar. So there is a major difference. Now here the removal of the names of the members from the membership register. A committee of a society shall remove from the register of its members the name of the person who ceased to be the member. First is removing the name from the register when they cease to be the member of the society. That is an action to be initiated by the committee. Or who stand disqualified. Who stand disqualified. Now we have seen the person may be disqualified to become a member when there is a conflicting interest, we have seen. So if a person stand disqualified, for example, how a person gets disqualified? Let us say there is a credit society. Now if it is a credit society, he should be staying or having his business operation within the area of society. Let us say my area of operation is K West, okay, K West Ward. In that case, I should be residing there, or I should be carrying out my business in K West Ward. But what happens is he gets transferred to Delhi. That means he is out of the operation. Neither he is staying nor he is having a business in the area of operation of the society. In that case, he is disqualified to be the member of the society. Okay, are you with me? Yes. So if he is disqualified, again his membership gets removed. Next is, or under the provisions of this act, for the being the member or continuing to be the member, he is disqualified by or under the provisions of this act. For being a member, there has to be certain conditions to be fulfilled. if he is not fulfilling those conditions which we have seen under section 22, so that he should be in the area of operation, he should be certain individuals, all that we have seen. So if he is disqualified by or under the provisions of this act for being a member or continuing to be the member of the society, that means even to continue to be a member he should be qualified. If he is disqualified to be continuing to be a member, that means the society can remove his membership. One, when he ceased to be the member. Second, he is disqualified and he is not having qualified under the act to continue as the membership. Now provided that, the moment we have seen provided means it is an exception to the general law. We have seen the general law, provided that if the society does not comply with the requirement of this section, the registrar shall direct such society to remove the name of such person and the society shall be bound to comply with such direction. What it means? It means it is the duty of the society to remove his name the moment he ceased to be the member of the society. But if the society does not remove on the application made by any aggrieved person to the registrar can remove such members from the register of members. Now for removing, when we talk about registrar may appoint an authorized officer on his behalf, issue an order, and that person will go to the society, and by going to the society he will remove from the register of members the person who is ceased to be the member of the society. So that means whose duty it is to remove the membership? Committees. Now in the case of a housing society, whether this type of provisions are there? The answer is yes, it is there. Now since we are more concerned with the housing society in Mumbai, now let us talk about a person. We have said here, a committee of the society with the register of members, the names of the person who has ceased to be the member. Who ceased to be the member? Now who ceased to be the member? We have already seen. Or who stand disqualified by under the provisions of this act for being the member or continuing to be the member under this act. In a housing society, to become a member, what is the most important condition? He should have a right, title, interest in the property. If he does not have the right, title, interest in the property, then what happens? Naturally, he ceases to be the member because he is disqualified. So, in such case, the society can remove their name. Secondly, in order to become a member now, we know that a person need to be paying stamp duty and registration. He should have a registered agreement. Suppose a society has admitted him as a member of the society based on undertaking, based on indemnity, saying that he will pay the stamp duty within 3 months, 6 months. Based on certain conditions, you have admitted him as a member. But in spite of that, he does not comply with that. That means he now becomes disqualified to continue in the society. So in that case also you can remove his membership. So now what happens? Provided that if the society does not comply with the requirement, suppose any aggrieved person is there, he comes to know that his names are not removed, then in that case they can complain to the registrar, and the registrar, by giving a show cause notice and calling for the information, also is entitled to pass an order to remove, and thereafter he can also appoint an authorized officer to get the names deleted. Any questions so far?
Sir, so associate member can be removed with this process. Associate membership.
Associate member whose name is appearing in the share certificate, okay, can be removed. Yes.
Not the joint member. The
joint member cannot.
Which we are using after 2019.
Joint member cannot be removed because his names are already there in the agreement.
Yes.
And therefore he cannot be removed.
Yes.
If his names are appearing as a joint member in the share certificate and he is not holding the right, title, interest in the property, yes, then under section 25A, yes, his names can be removed. Okay. So section 24 we are talking about types of members and their privileges. 24A we are talking about education and training. 25 we are talking about cessation of member. 25A we are talking about removal of the member.
Sir,
Yeah.
you said one of the disqualification was if the agreement is not registered and proper stamp duty is not paid. But section 41 it says exemption from compulsory registration of agreement, which we have given a legal opinion also previously.
Correct.
That agreement registration is not compulsory.
Correct.
So what about that?
Yeah. Section 41, that is about exemption of registration of certain document for the purpose of, that is a privileges given to the society. Now, of course, under that section, you need not register the agreement. But if you look at the section in the chapter 154B, that is chapter 13B, which we are talking about a housing society. Now that is a special chapter for the housing society. There it says registration is compulsory. So if there is a conflicting provision, the special provision will apply. Here is a general provision for, let us say, I am just giving an example, in the case of share transfer from one person to another person, okay, there you don't require registration. That is what is section 41 is talking about, to transfer the shares. But in a cooperative housing society, because it is got a special character of property transfer, therefore section chapter 13B, which is a special chapter for housing society, that as prescribed, to become a member of the society, then you have to have a registered agreement. So the membership condition for a housing society is different than this, and this was prevailing because at that time there was no separate chapter for housing society. Okay, so this is applicable for the transaction prior to 9th March 2019. Okay, there is a High Court judgment also to that effect, Nisha Dongre. So in that case also section 41 has been considered, and there it has been said that for the transfer of membership there is no need of registered agreement. But that does not become valid now because there is a change in the Act. 9th March 2019 is the cutoff date where it says to become a member of a housing society you have to have the registered agreement. Okay.
So we can say 41 154B12 has an overriding effect on section 41?
Absolutely. It has an overriding effect because it is a special chapter for the housing society. Whenever there is a special provision for a particular type of society, general provision gets overridden. Okay. Now you can also see 154B, since you are there, just look at what sections are applicable and not applicable. Just see whether section 41.
Yes, it is applicable.
Just see.
41 is applicable.
Munatis.
Yeah, 41 is applicable.
Okay. Fine. Yeah.
So, but if suppose one of the person become a member prior to 2019 on the basis of unregistered agreement, so whether that can be challenged today? No, right?
It should not be challenged. It should not be challenged because at that prevailing provisions he was entitled to become a member. Now subsequent provision will not make him disqualified. Now let us come to section 26. No rights of the membership to be exercised till the payments are made. This is the heading. A member shall be entitled to exercise such rights as provided in the Act, rules and bylaws. Provided. That means every member has a right to exercise his rights as a voting or attending the meeting and other privileges as provided in the Act, rules and bylaws. Provided, what are the conditions? Provided means either they are called conditions or they are called as exception. Provided no member shall exercise the rights until he has made such payment to the society in the respect of membership. Very important. To become a member, he has to pay the entrance fees, he has to pay the share money. So whatever is the share money or entrance fees, what is required, unless until he pays, he cannot exercise his voting right. Or acquired such interest in the society. As I was saying, acquired such interest in the society, which means I am talking about in a housing society, acquired such interest in the society. That means he gets an interest in the property. So of course we have now the special section, otherwise he cannot exercise the voting right or the members' right unless he acquired such interest in the society as may be prescribed, that is given in the rules and specified under the bylaws of the society from time to time. So the bylaws and the rules both are very important. So he has to make the membership amount, he has to acquire the interest if that is the requirement of the Act or the bylaws and the rules. Provided further, there is a second provision that in case of increase in the minimum contribution of membership in the share capital, to exercise the rights of the membership, the society shall give a due notice of the demand to such member and give a reasonable period to comply with it. Which means in case the members' contribution capital is increased from, let us say, 250 rupees to 500 rupees or 1000 rupees to 2000 rupees, in that case they should be given a sufficient time to comply with the requirement. And if they don't comply within the specified time period, then they do not entitled to exercise the members' rights. Subsection 2 says it shall be the duty of every member of a society to attend at least one general body meeting within a consecutive period of 5 years. Duties of the members. So these are the duties of the members, to attend at least one general body meeting within a consecutive period of 5 years. Of course, this is not applicable to housing society because this particular section has been done away with for housing society. Provided that nothing in this clause shall apply to the member whose absence has been condoned by the general body of the society. Now what happens in the every general body, they pass a resolution that the people who remain absent are given a leave of absence. So by doing that, what happens is their active membership does not get disqualified or removed, or the status does not get removed. Now coming to the next B, to utilize the minimum level of service at least once in a period of 5 consecutive years as specified in the bylaws of the society. Now to utilize the minimum level of service at least once in a period of 5 years, consecutive 5 years as specified in the bylaws of the society. What do you mean by minimum service? What happens? Economic participation is another. Economic participation of a member in a cooperative society is also equally important. So we have seen one, education and training is one of the principles of cooperatives, which has been covered under the section 24A, education and training. The other one is economic participation. What do you mean by economic participation? Economic, the moment we talk about economic, that means it is talking about business transactions. Cooperative society is registered to carry out the economic activities. That means business activity. Now, economic participation is one of the principles of cooperative. So every member should participate in the business of the society. What is the amount of the business that he has to carry out? What is prescribed in the bylaws. Now for example, let us say you are a member in a cooperative bank. Okay. Now in the cooperative bank, what is the business of a cooperative bank? Naturally we know accepting deposit and give loan. Okay. This is the main purpose of the cooperative bank. In that case, the bylaws may say that within the 5 years, you should keep, let us say, 10,000 as your deposit, and at least you should take 1 lakh rupees as the loan. If you want to be an active member in the society or in the bank, if you are not fulfilling this condition, then you become a non-active member. That means in 5 years you are not able to fulfill this condition. That means you are not entitled to be continuing as a member. Because if you are a member, then the purpose is to carry out the economic activity. You become a member just for the voting purpose and you don't carry out the economic activity, you do not contribute in the business of the society. That means you are not entitled to continue in the membership of the society. So one of the principles of the cooperative societies, cooperative society or cooperative enterprise, is to have an economic participation of the members. So that economic participation has been prescribed under section 26. Section 26, subsection 2, clause B says, to utilize the minimum level of service at least once in a period of 5 consecutive years as specified in the bylaws of the society. Provided that a member who does not attend at least one meeting of the general body as above and does not utilize the minimum level of service at least once in a period of 5 years as specified in the bylaws of such society shall be classified as a non-active member. Of course, now after the 97th Constitution has been set aside by the Honorable Supreme Court, Union Government versus Rajesh Shah, recently it has been set aside in the year 2022, March, it has been set aside, 97th Constitutional Amendment has been set aside by the Supreme Court. After that, an amendment has been carried out in the MCAs Act saying that active member and non-active member has been done away with. Now, the classification of active and non-active member is not applicable in a cooperative housing or cooperative societies, whether it is a housing or otherwise. Third provision, provided further that when a society classifies a member as a non-active member, the society shall in the prescribed manner communicate such classification to the concerned member within a 30 days from the date of close of the financial year. Of course, now this is not applicable. Provide also that a non-active member who does not attend at least one meeting of the general body and does not utilize minimum service as specified by the next 5 years from the date of classification as a non-active member shall be liable for expulsion under section 35. So suppose a member become non-active, he can be expelled. Now of course, as I said, active and non-active member is now not applicable. Provide also that a member classified as a non-active member shall on fulfillment of eligibility of a criteria as a provided in this subsection shall be entitled to be reclassified as an active member. Entire active and non-active member has been removed by an amendment done in the year 2021. So the amendment has now already been done, 22. The amendment to remove the active and non-active member has been already done. Provide also that if a question of a member being active or non-active member arises, an appeal shall lie to the regime within a period of 60 days from the date of communication of classification. Now this is also not applicable. Provide also that in any election conducted immediately after the date of commencement of Maharashtra Cooperative Societies Amendment Act 2013, that is after the 97th Constitution, all the existing members shall be eligible for voting unless otherwise ineligible to vote. That means they are all considered as an active member after the commencement of the act. Now let us come to section 27. Again 25, 26 and 27 is not applicable to housing society. However, for others, section 27, save as otherwise provided in the subsection 2 to 7, both inclusive, no member of the society shall have more than one vote in its affairs, and every right to vote shall be exercised personally and not by proxy. So proxy is not allowed. They have to be personally, every right to vote shall be exercised personally. So the personal participation is another principles of cooperative. Cooperative runs with the personal participation. So because of the personal participation, that means member has to be personally participating. So this provision is there that every right to vote shall be exercised personally. Now one man, one vote is again one of the principles or democratic principles where one person, one vote. So that this provision takes care of that. Save as otherwise provided in the subsection 2 to 7, no member of a society shall have more than one vote in its affairs. So he will have one vote, irrespective of the share capital that he is holding, irrespective of the area of, the business that he carries out, irrespective of the area he is occupying in a housing society, everybody will have one vote and every right to be voted personally and not by proxy. Because many times people ask where it is written one person, one vote. And many times they ask where it is written that proxy is not allowed. Of course, bylaws also provides that, still in the act also it is given. Provided in the case of an equality of votes, the chairman shall have a casting vote. What is casting vote? Casting vote means it is an additional vote. So that means as a chairman, if there is a tie, then he has one more vote. So that means chairman will have enjoyed two votes in case of tie. Otherwise, chairman also as a member will have only one vote. Only this is an exception where chairman will have a casting vote, whether it is a managing committee meeting or whether it is a general body. Explanation: for the purpose of this subsection, votes to more than one candidate from the panel shall be treated as one vote. Now this has been added because what happens is, in a society when you want to elect a person, so naturally there can be 7 candidates, 10 candidates, 15 candidates, 21 candidates. So if there are 21 candidates are standing, that means you can vote 21 candidates. So therefore it is said, for the purpose of this subsection, votes to more than one candidate from the panel shall be treated as one vote. Okay. Notwithstanding anything contained in subsection 1, an active member who subsequently fails to participate in the affairs of the society and to use the service up to the minimal level specified from time to time in bylaws shall cease to be the active member and shall not be entitled to vote. If he is non-active member, he was not entitled to vote, but now active member and non-active member is not applicable. Now let us talk about section 2 to 7, which is giving us the rights of vote. Where a share, because voting members of the society is the heading, where a share of a society held jointly by more than one person, the person whose name stands first in the share certificate, if present, shall have the right to vote. That means it is the first member who will have the voting right, because he is the member of the society. But in his absence, the person whose name stands second, and in the absence of both, the person whose name stands next, and likewise in the absence of the preceding person, the person whose name is next on the share certificate, who is present and is not a minor, shall have the right to vote. He should not be a minor, but otherwise he has a right to vote in the consequence. Subsection 3 says, a society which has invested any part of its funds in the shares of any federal society may appoint one of its active members to vote on its behalf in the affairs of that federal society, and according such members shall have a right to vote on behalf of the society. A society which has invested any part of its funds in the shares of a federal society, that means you are now a member of a federal society. You are not a primary society, you are a federal society. In that federal society, primary society becomes the member, and by investing the money, in that case, primary society can appoint any one of its active member to vote on behalf of its affairs of that federal society, and such member shall have a right to vote on behalf of the society which is a primary society. And here there will be a resolution passed, and based on that resolution the resolution will be submitted to the society as to who will be the attending the meeting and who will vote. Provided that any new member society of a federal society shall be eligible in the affairs of that federal society only after the completion of a period of 3 years from the date of its investment any part of its funds in the shares of such federal society. What it means? It means that in the case of a federal society, if somebody is becoming a member, that is a primary society is becoming a member, then they will be entitled to vote after the expiry of 3 years from the date of becoming the member. So for a period of 3 years, they are not having the voting rights. Any individual member of a society shall not be eligible for voting in the affairs of that society for a period of 2 years from the date of its enrollment as a member of such society. In case of any other society, in the case of federal society, what is required? 3 years voting period. In the case of any other society, wherein primary society, where an individual member of society shall not be eligible to be voting of the affairs for a period of 2 years from the date of its enrollment as a member of the society. Whether it is applicable to housing society? The answer is no, because in a housing society, this is not required. Now, can you tell me why this particular provision has been added? Can you apply your mind? What could be the reason why there is a waiting period of 2 years is required? Why this provision? If I become a member, next day I should get a voting right. In a case of a housing society, you are anyhow getting a voting right on the day you are admitted. But in the case of other society, 2 years waiting period. Why? Kya reason ho sakta? No. The basic reason is that the people who are in the helm of the affairs, okay, that means who are in the managing committee and they want to get re-elected. During the election year, what they may do is they will appoint or enroll their relatives, their friends who will be voting them. So the enrollment of the members in the voting year or the election year will increase and accordingly they may get re-elected. Are you getting my point? What happens? For example, let us say I am running a credit society, okay, or a cooperative bank. Leave aside the housing society. I am running a cooperative credit society. Okay. Now in the credit society, I know there are two groups. Okay. One group, let us say last year they lost by marginally say 100 votes, 200 votes. And we have won by 100 votes. This time, these people have enrolled more and more voters. Okay. And because we are also now aware that from our group, how many people are going to be admitted. And if I want to get elected, then what I will do, I will enroll the members by taking 100 rupees as a share money. I will go on enrolling thousands and thousands of members. And then those people, I will get them to vote and then I get re-elected. So in order to, stop these manipulations, the law has provided that 2 years waiting period at least should be there so that the membership, voting rights are not manipulated. Secondly, the economic participation, section 26, where we have seen, active member and non-active member, it was a very important thing because what happens is somebody may just enroll by paying 100 rupees or 10 rupees as a member and they don't take any economic participation in the business, but in the election they will come and vote their own candidates. So in that case, the entire purpose of becoming a member gets defeated. Anyhow, now the active and non-active member has been done away with. Only thing is that the enrollment of the members, the voting rights are, they have to wait for 2 years from the date of enrollment. Okay. Provided that nothing in this section apply in the respect of cooperative housing society and a cooperative premises society. So that means it has been made very clear that 2 years waiting period is not required for a housing society. In fact, even if you look at the special chapter, there also it says he is entitled to vote from the day he is enrolled. Now section 27 as such is not applicable to a housing society because this is a provision provided earlier. Anyhow, subsection 4, a company or any other body corporate constituted under any law for the time in force which has invested any fund in the shares of the society may again appoint any of its director or officer to vote on its affairs of such society, and accordingly such director or officer shall have the right to vote on behalf of the company or a body corporate. That means by passing a resolution, you can appoint any directors or the officers of the company or the corporate body. Where a firm has invested any part of its funds in the society, any one of its partners appointed by the firm shall be entitled to vote in the affairs of the society. Whereas this is not so in the case of a housing society. In the case of a housing society, it says any authorized person. That means firm can appoint any authorized person, the company also can appoint any authorized person, trust also can appoint any other person. A local authority public trust which has invested a part of the fund shares of the may appoint any of its members or trustees to vote in its affairs on its behalf in the affairs of that society, and according such persons shall have the right to vote on behalf of the local authority or the public trust as the case may be. This particular thing is very important when we talk about elections. In the case of a federal society, the voting rights of individual member thereof shall be such as may be regulated by the rules made there under this act and by the bylaws of the society. That means in the case of a federal society, the voting rights of individual members thereof shall be such as may be regulated by the rules made there under this act or by the bylaws of the society. In case of a federal society, the voting rights of individual members. When we talk about individual members, that means a federal society, who will be a member of a primary society? Primary society becomes the member of a federal society. So when we talk about individual member, which means we are talking about not the what you call this is artificial member, that means a jurisdiction person, that means a legal body. Here it should have been mentioned about the member anyhow. So voting rights of such primary society thereof, it should have been such primary society shall be such as may be regulated by the rules made under this act and by the bylaws of the society. Now, in a case of a housing society, we know there is something called federation. We form a housing society federation. Now, the Housing Society Act provides for two societies to become the apex body, correct? They can form association of society. If two society can form an association of society and each society has one voting right and you need minimum 5 committee members, how it is possible? That is not possible. Therefore, in the case of a federal society, the individual societies, how to represent in the federation is regulated by the bylaws. So in the bylaws we can mention that every 25 flat owners there will be one member to represent in the federation or apex society or in the form of association of society. That is how we can do. No nominal member shall have the right to vote and no such member shall be eligible to be a member of a committee or for appointed as a representative of the society or any other society. A nominal member does not have a voting right. No nominee of the government or any financing bank on the committee of any society shall be entitled to vote at any election of the officers of such committee, such as the president, vice president, chairman, vice chairman, secretary, treasurer or any other officer by whatever designation called, who holds the office by virtue of his election to that office. Which means if there is society where there is a government nominee, that government nominee cannot elect or vote for the purpose of electing chairman and secretary or the vice president. So this is how the provisions have been made. No nominee of the government or any financing bank on the committee of any society shall be entitled to. I think this is very clear. Voting powers, subsection 10. If a member has taken a loan from the society, such member shall, wherever he is defaulter as provided in explanation to clause 1 of subsection 1 of section 73 CA, have no right to vote in the affairs of the society. If a member has taken a loan from the society, such member, whenever he is a defaulter as provided in the explanation to clause I of subsection 1 of section 73 CA, have no right to vote in the affairs of the society. If he is a defaulter, he does not have the voting right. But of course now I think this may not be applicable because now active member and non-active member has been done away with. We will have to see that. But of course it is not applicable to housing society. Provided that a member shall not be deemed to be a defaulter if he has discharged his obligation to deliver his marketable produce to the marketing or processing society and the value of such produce not less than the amount of his dues, even if the actual settlement of his dues either in whole or in part takes place at a later stage. So this is a provision wherein it is exception in the case of marketing and processing society. So I think we are not required to deal much on this. The agricultural credit society may issue suitable orders for the purpose of carrying out the provisions of this. So subsection 12 has been deleted. The agricultural credit society may issue suitable orders for the purpose of carrying out the provisions of subsection 10. Okay. In any society, no member other than the government or other society or with the previous sanctions of the state government, a Jilla Parishad constituted under the Maharashtra Jilla Parishads and Panchayat Samiti Act 1961 shall. So restriction on holding of the shares. Section 28 talks about what are the maximum shares a member can hold. This is a restriction on holding of the members. So in any society, no member other than the government. So government can hold any share, government or any other society. No member other than the government or any other society or any other society or with the previous sanction of the state government. So that means a state government can notify to have more shareholding. A Jilla Parishad constituted under the Maharashtra Jilla Parishad Act shall hold more than such portion of the total share capital of the society, in no case exceed 1/5 thereof, as may be prescribed. That means what is prescribed is the rules. So they cannot hold more than 1/5 of the holding. Let us say if the total shares are 5,000 rupees, so one can hold not more than 1,000 rupees shares. So if he has to have more than 1/5, then there has to be specific government permission. There has to be specific law which provides him. Okay. Have or claim any interest in the shares of the society exceeding 20,000 rupees. That means even he cannot have more than 20,000 rupees. If he wants to have more than 20,000 rupees in a society or in a cooperative bank or anywhere, then it has to be specially provided by the government by way of notification. In the case of a cooperative banks, they are allowed to have more than, I think, up to 5 lakhs they are permitted to have, but that relaxation is given by a special notification by the government. Okay. Next, provided that the state government by notification, as we said, official guides specify in respect of class of society or higher or lower maximum than 1/5 of the share capital, as case may be higher or lower amount of 20,000 rupees. That means state government by notification can either increase or lower it. Okay? For a particular class of society. Now section 29. Now these are the sections 26, 27, 28, 29. They are not applicable to housing society. But because they are there, we will see. Restrictions on transfer or charge on the shares or interest. Subject to the provisions of the last preceding sections as to the maximum holding of shares and to any rules made in this behalf, a transfer or a charge on the share or interest of a member in the share capital of the society shall be subject to such condition as may be prescribed. Restriction or charge on share or interest. That means restriction on transfer. There are conditions or restrictions for the transfer of shares. What are the restrictions? Or even the restriction on charge on the shares. There can be a charge on the shares or interest in the capital of the society. Subject to the provisions of the last preceding sections, subject to the provisions of the last preceding sections, as the maximum holding of the shares, that means we have seen that 1/5 or 20,000, okay, or as per the government notification, subject to the provisions of the last preceding section as to the maximum holding of the shares and to any rules made in this behalf, a transfer or a charge on the share or interest of a member in the share capital of the society shall be subject to such condition as may be prescribed. As may be prescribed means as may be mentioned in the, where it is mentioned, rules. Prescribed means rules. Subsection 2 says, a member shall not transfer any share held by him or his interest in the capital or property of the society or any part thereof unless he has held such shares or interest for not less than 1 year. That means in order to transfer the shares, before transferring the shares, he should be holding the shares for not less than 1 year. Are you with me? So that means he has to hold the shares for a period of 1 year. Now, whether this is applicable to housing society, the answer is No, because section 29 is not applicable to housing society post 9th March 2019. Prior to that it was applicable, therefore people used to say that under section 29 subsection 2 clause A, he was supposed to hold it for more than 1 year. Now what could be the reason for saying that a person should hold the shares not less than 1 year? The way we have seen that he should not vote for in any affairs of the society unless until he holds the shares for 2 years. That we have seen, because in the voting or election year one should not go on enrolling the member and increase the members and then only those people vote, and then there will be rigging of the elections. So to stop that manipulative practice, 2 years is given. Now he has to hold the shares or interest for not less than 1 year. Why this provision must have been included? To avoid, when you say transfer, it also talks about refund. Okay. Now what happens when you do any business? Okay. So the capital is most important aspect. Okay, in any business. Suppose you start a cooperative credit society. I am just giving an example. Say there are 100 members in a cooperative credit society and everybody has contributed 10,000 rupees. Now we have how much? The transfer is made to a member of the society or to a person whose application form has been accepted by the society, or to a person whose appeal under section 23 of the Act has been allowed by the registrar. See, whose appeal under section 23 in bracket 2, appeal is under section 23 2. So to a person whose appeal under section 23 of the Act has been allowed by the registrar, or to a person who is deemed to be a member under subsection 23 1A. Again, deemed member also has to be, you have to appeal under section 23 and he has to be allowed. Okay. 23 1A is about the refusal of the membership, application itself, not the membership, application itself, and then to the registrar you apply. Now, section 29, restriction on transfer of or charge on the share or the interest, notwithstanding contained in subsection 1 and 2, where a member is allowed to resign or is expelled or cease to be a member on account of his being disqualified by this Act or by the rules made thereunder or by the bylaws of the society, may acquire the share or interest of such member in the share capital by paying for it at the value determined in the manner prescribed. What do you mean by this? Section 29 subsection 3 says, notwithstanding anything contained in subsection 1 and 2, whatever is mentioned in section 1 and 2 regarding transfer of shares, we have seen that. Correct. Section 29, subject to the provisions of the preceding section, okay, as to the maximum holding of shares and to any rules made in this behalf, a transfer or charge on the share interest of the capital of the source shall be subject to such condition as may be prescribed, whatever condition that is prescribed in the rules. Secondly, a member shall not transfer, there are two sub conditions, that he should hold the shares for more than 1 year, and transfer is made to the member of the society to whose application for membership is accepted. The transfer has to be made to the person whose membership is accepted or who has been admitted by the registrar under the appeal under section 23. Okay, either transfer or this. Correct. Now, subject to this, whatever is said, notwithstanding this, we can also refund the money. That means we can refund the money. If he does not want to transfer, the society can buy back the shares. Are you with me? It is called buybacking the shares. Shares can be bought back. That is what I was saying. That suppose today 100 people have invested, out of that 10 people want to withdraw from this, so they don't get a new person. In that case, the buyback of shares is possible for a for a society, which is not possible for easily in a company. In a company, they have to either sell in the market. The company cannot buy back the shares unless until there is a special resolution passed and then all these formalities are completed. Normally, in the normal day, that is not permitted. Whereas in the case of a society, the shares can be refunded. The shares can be bought by the society themselves. So, notwithstanding anything contained in subsection 1 and 2, where a member is allowed to resign. Now, he is allowed to resign. He is allowed to resign from the membership. Or he is expelled. Now, we have expelled. So, because we have expelled him, we have to refund his money. Or ceases to a member. That means on account of death. Because of his death, now death means legal heir will get. Here, ceased with a member on account of being disqualified by the act, because now he is a conflicting interest and therefore he is disqualified, or by the rules made thereunder or by laws of the society may acquire the shares of the interest. Who may acquire now? Society themselves may acquire the shares of such member in the share capital by paying for it at the value determined. Now, what is the value? It at the value determined in the manner prescribed. In the manner prescribed means given in the rules. So, we will have to go to the rules, how the valuation of the shares is done. I will just give you an example. Valuation of shares are done by, you can just, so valuation of shares, see the valuation of share is done very simply like this. See capital, whatever the share money you have invested, let us say we have 10,000 shares of rupees 10 each, okay, 100 each. So, how much it becomes? 10 lakhs. This is my share capital. Last 5 years I have done the business, so my reserves are there, okay. So, let us say the reserves are added 5 lakhs. Now, there are no other loss, nothing. Let us assume the reserves means profit. So, what is the total net worth of my credit society? 15 lakhs. Now, I want to refund the share money. What will be that I will be refunding as prescribed in the rules? Now, what is prescribed in the rules? Rule says the value of the share as determined in the last audited balance sheet. Last audited balance sheet. Let us say this is 31st March 2022 and refund has come in the October 2022. Now, what is the audited year? This, okay. Now, as per the audit report, last audited report, what is the value of the share now? 15 lakhs. That means 10 lakhs is the shares, 15 lakhs is this. So, that means 150 rupees. Now, will I refund 150 rupees per share? What is the value that I will be refunding? The rule says it will be the face value of the share, what is invested, or net value of the shares, whichever is lower. Face value of the shares or net worth, whichever is lower. Now, this is no doubt the value of the share has become 150, but I am going to give him how much? 100 rupees. Now, that is paid up value. Face value means paid up value, or the net worth, whichever is less, will be refunded. Now, on 31st March, let us say there is a loss, 5 lakhs. Now, what will be the value of the shares now? 5 lakhs. Now, the refund has come. Now, we want to acquire because people want to take back the money. Then, how much I will give them? I will give them how much? The value of the share is now 50. So, I will refund them how much? 50 rupees. Correct? So, the people are joining for the cooperative society. That is one of the principles of cooperatives, not to make profit, not to have the capital appreciation. They are coming for a economic participation, they are coming for a common good, they are coming for a democratic principles, and they are not coming here to get the appreciation in the value. However, they want to resign, yes, they can resign. In that case, the society can give them the refund. The refund will be either the paid up value or the net value of the shares as per the last audited balance sheet, whichever is lower. Okay? This also can be one of the mismanagement. Of course, in a housing society it does not happen, but in a lot of credit societies, cooperative banks and consumer society, when the refund happens, they give without looking at this, they give at the face value. How much? 5,000 rupees they dete, whereas the actual value could be less than that. In that case, there is a drainage of the capital. The capital gets drained.
So, suppose if person get disqualified and then he ceases to be a member. In that case, society is taking back the shares by whatever amount it comes, whether it is face value or net value. After some years, when that person becomes again eligible for being member of a society, at that time again he will be purchasing at what rate?
Face value. There, when you are issuing the shares are always issued at the face value. Okay. Whereas when you are refunding, that will be either face value or the net value, because if the capital is draining, companies, society is doing a loss, people may go on buying the shares.
So at that stage again that person has to pay the security premium of 25,000.
Where premium?
When he becomes eligible for membership.
Which premium?
25,000.
Where? In a housing society? In a housing society, this is not applicable. In a housing society, normally transfer happens. In that we are talking about transfer premium. We are talking about general society. This is not applicable to, again, housing society. Housing society may not buy back the shares unless until he resigns and the society itself purchases the flat for their office purpose or anything. In that case, of course, they can pay only again the face value. Okay. Notwithstanding anything contained in subsection 1 to where a member is allowed to resign or is expelled or cease to be a member on account of his being disqualified by this act or by the rules made thereunder or by the bylaws of the society may acquire the share of interest of such member in the share capital by paying for it at the value determined in the manner prescribed. I have explained you, provided that the total payment of share capital in any financial year for such purpose does not exceed 10% of the paid up share capital of the society on the last day of the financial year immediately preceding. Again, the total refund in that particular financial cannot exceed more than 10% of the total paid up value. Suppose we have a paid up capital of 10 lakhs, that cannot exceed in a financial year more than 1 lakh rupees. So every year only 10% can be refunded. Okay, it cannot exceed. So if it is exceeded, then that is a violation. Explanation: the rights to forfeit the share or interest of expelled member in the share capital by virtue of any bylaws of the society will not be affected by the aforesaid provision. That means, if the bylaw says the shares will be forfeited, in the case of a housing society, we say share capital will be forfeited. So in that case, they need not be refunded. In this section, the expression financial year means year ending on 31st day of the March, or in the case of any society or a class of accounts of which are with the previous sanction of the registrar balanced on any other day, the year ending on such day. That means normally it is a financial year. Earlier 30th June used to be the cooperative year. Now it is financial year. Subsection 4. Where the state government is a member of the society, the restrictions. Okay. So what it says, where the state government is a member of the society, the restrictions contained in this section shall not apply. So in the case of a state government, section will not apply for transfer made by its share or interest in the capital of the society, and that government may, notwithstanding anything, and withdraw from the society its share capital at any time after giving the society notice thereof, not less than 3 months. Government may give a 3 months notice and then they can withdraw their money. Section 30. Transfer of interest on death of a member. If a person expires, how the transfer will happen? Of course, this is again not applicable to housing society. On the death of a member of the society shall transfer the share or interest of the deceased member to a person or person nominated in accordance with the rules, or if no person has been so nominated, to such person as may appear to the committee to be the heir or legal representative of the deceased member. That means it can be transferred to a deceased nominee or to the legal heir. Any question on this? Legal representative. However, the committee, again this is not applicable to housing society, this section, but generally it is transferred to the nominee or to such person as appear to the committee to be the legal heir, legal representative of the deceased member, provided that such nominee heir or legal representative, as the case may be, is duly admitted as a member of the society. They will be admitted as a member of the society. And then it also says, provided further that in this subsection or in section 22 shall prevent a minor or a person of unsold mind. That means section 22 says he should be major to become member. However, in the case of a transfer to the nominee or to the legal heir, he may be a minor. So minor can be admitted on account of death of the member, provided further that nothing in this section shall or in section 20 shall prevent a minor or a person of unsound mind from acquiring by inheritance or otherwise any share or interest of a deceased member in the society. Through a guardian they can. Subsection 2 section 30 says, notwithstanding anything contained in subsection 1, any such nominee, heir or legal representative as the case may be, may acquire the society to pay to him the value of the share or interest of the deceased member ascertained in accordance with the rules. As I was saying, notwithstanding anything contained in subsection 1, any such nominee or heir legal representative as the case may be, may require the society to pay to him. That means they may ask the society to buy back the shares. A nominee may say, I don't want to continue as a member. In that case, once the shares are transferred in their name, they may request the society to refund the money. In that case, they don't have to hold it for more than 1 year. Okay. So, notwithstanding contained in subsection 1, any such nominee, heir or legal representative as the case may be, may require the society to pay to him the value of share or interest of the deceased member ascertained in accordance with the rules. I have given you the rules, how the valuation is done. Last balance sheet, net value of the share as per the last audited balance sheet, or the face value, whichever is less. Subsection 3, a society may pay all other monies due to the deceased member from the society to such nominee, heir or legal representative as the case may be. If there are any other dues, let us assume there is a deposit or there are any other dues. Let us say it's a agriculture society where the deceased member before death he has given some commodity to the society for which they were required to pay some money. Let us say it is a sugar factory. In that case they give the sugar cane, and once the sugar cane is given, that is accounted for, and when it is accounted, they are paid only after the sugar is made and the marketed money is received. In that case, meantime if the person dies, that means the amount is payable to that deceased member will go to the representative. All transfers and payment duly made by the society in accordance with the provisions of this section shall be valid and effectual against any demand made upon the society by any other person. That means all transfers duly made by the society in accordance with the provision of this section shall be valid and effectual against any demand made upon by the society any other person. If there are any other legal heirs or anybody claims, then the society will not be held responsible. It is valid. Shares or interest not liable to be attachment. This is very important provision. The share or interest of a member in the capital of the society or in the loan stock issued by a housing society or in the funds raised by the society from its members by way of savings deposit shall not be liable to attachment or sale under decree or order of a court for or in respect of any debt, liability incurred by the member, and accordingly neither the official assignee under the Presidency Towns Insolvency Act 1909 nor a receiver under the Provisional Insolvency 1920 or any such person or authority under any corresponding law for the time being in force shall be entitled to or have any claim on such share or interest. Have you understood this? What it means is that, just to take you for, if there is a share capital of a member in the society, okay, and tomorrow that person becomes insolvent, then because he has become insolvent, the liquidator, for the purpose of liquidating his asset or recovering their money by way of amount, then they cannot come to the society and ask for the refund. The legal heirs can ask, the same member may ask, but a liquidator, because he has become insolvent, that money he cannot demand. Any other person, any institution by any order or the decree cannot recover the money which is invested in a society in the form of capital or the deposit. Yes?
In the last section you were saying if the society releases the monies, the society cannot be held responsible.
Correct.
But I think there would be a rider. Suppose there is a charge on that member in respect of shares or whatever.
No, see, you are talking about housing society. You are talking about housing society. The shares is one aspect and the flat is another aspect. Flat, he is the owner of the flat. The flat has been created charge. In that case, yes, the company will have the charge on that.
Then the society cannot release that.
No, they cannot.
Yeah.
They cannot. See, all transfers and payment duly made by a society in accordance with the provisions of this section shall be valid and effectual against any demand made upon the society by any other person. What we are saying, section 30 is related to transfer to the legal heir or to the nominee. If it is transferred to the nominee or the legal heir and based on that certain payments are made of the share capital, we are not talking about the flat, ownership of the flat. This section is not applicable to housing society at all. So let us not talk about that. Okay? Share or interest not liable for attachment, I think we have understood, because the heading itself, transfer of interest on death of a member, and share or interest not liable for attachment. That also we have seen that it is not for attachment. The capital of the cooperative society cannot be attached by any insolvency proceedings. Okay? By court order. Now, rights of a member to see books of accounts. Section 32 talks about rights of a member. Now, every member of the society will be entitled to inspect free of cost at the society office during the office hours or at the time fixed for the purpose. So, a copy of the Act, MCA's Act, the rules, that is the second, and the bylaws, third. Fourth is last audited annual balance sheet. That means he can see only the last audited balance sheet, profit and loss account of the last year, a list of members of the committee, a register of members, I-form, the minutes of the general body meeting, minutes of the committee meetings, and those portions of books and records in which his transaction with the society have been recorded. That means these are the only documents which we can see. Section 32, and similarly in the housing society also, section 154B, I think 8. Section 154B 8 is the replica of the same. Whatever is written here, same thing is written there. So for rights of the member to see the books of account is only limited to this. He cannot go, because many of the society we have seen, the members ask for vouchers, they ask for quotation, they ask for the bills. Those things are not permitted. They cannot ask because there is an auditor, independent professional who is appointed, who is in the panel of auditors. So therefore, once there is an auditor who is going to verify, the members cannot ask for all those things. Next.
So here, records with respect to his transaction with the society. It means with respect to his particular flat. Today he has acquired membership in the year 2018. So after 2018 he can ask for inspection with respect to that flat. But before 2018, if he is asking for 10 years prior when he was not the member, but with respect to that particular flat, so whether that can be given for inspection?
No, as far as that particular flat is concerned, if there is a dues which he has to pay, then he can ask for those, what is paid, what is not paid, ledger account he can ask. But if there is nothing to be paid, he is not at all concerned, then there is no question of asking. In that case, he cannot ask. Say, suppose he is become a member today, that means there was nothing outstanding shown against that flat. In that case, in what way he is connected? He is not connected with that. He can ask only from the day he has become the member, not prior to that.
But then it defeats the concept of cooperative society.
What is that?
It is ultra-virus to the idea, the concept.
What is that concept?
If in the society you are all coming together for the betterment of each other, of progress and things like that. So if something has gone wrong, that doesn't pertain to him personally, but to the society as a body corporate.
No, see, you are mixing up the issue. See, wait. See, one is making a complaint to the registrar or asking for certain information regarding the administration of the society. Okay. So he is entitled. He is entitled to question about the administration of the society. Okay. He wants to make any complaint to the registrar as a member, he has a right. Even though he has become a member today, about 5 years back, certain mismanagement he wants to complain, he can complain. Then the registrar will take a cognizance of that. What we are here is, every member of the society, what is his right to see the books of account? He can only see this portion. He cannot see beyond this.
That prohibits him from seeing other functioning of the society.
Absolutely. He is prohibited.
It is in the interest of justice. Why should you...
Leave aside. Today this is done by the assembly. This is the law of the land. I am not here to debate what the parliamentarian or assembly member of legislative body should do.
member bodies do anything, sometimes it is reversed by the court, sometimes.
No, no, ठीक है, no problem.
If it is otherwise.
Yeah, right now,
some
right.
wrong laws
See,
also are passed.
see, problem is, I'll tell you, in a cooperative society, people are coming and getting elected for the common good. And when they are doing it, there is an independent agency to verify whether the books of accounts are properly maintained, not maintained. There is a panel auditor. Section 81 provides for the audit. And there is a registrar to look after the overall administration. If you are not happy, you complain to the registrar by, 1/5 of the members. Then the registrar can initiate an inquiry under Section 83. So he can also inspect the books of account. He is entitled. Now, what happens is, if a society has got, let us say, 10,000 members, and everybody wants to come and see the balance sheet, okay, agreed. But they want to come and see the vouchers. Today one member comes and sees the voucher. Now tomorrow, if it's a cooperative bank, then every member will come. You are given to Sangar Jadhav 10 lakh rupees. Show me his loan document, show me his books of account, show me this, show me that. So that is not possible. If it is a credit society, Nisha has taken 10,000 loan and you are also there. I want to see Nisha 10,000 liya hai ki ज़्यादा लिया, उसका क्या security है, क्या नहीं. So are you getting my point? So then if there are 10,000 members, the committee is going to show the records to all the 10,000 members. That is not possible. You have enough time, not privacy. This is something which the law says that these are the only documents you can see, but you need not see and you are not allowed to see the others transaction.
Yeah.
By allowing you to see others transaction, you are creating a RIP, and that RIP should not happen. Okay. You should believe, you are allowed to go through the minutes of the book, you are allowed to go to the general body records, all that is allowed. A society shall furnish to the member, now subsection 2 says, a society shall furnish to the member on request in writing and on payment of such fees as may be prescribed, therefore, a copy of any of the documents mentioned in the foregoing subsection within 1 month from the date of payment of such fees. So within 1 month it has to be given. 32A, certain societies give passbooks to the members and entries in such book evidence of the amount due. Like credit societies and even agriculture society, if they are giving some produce, the passbooks are given.
So can I invoke 32 before becoming a member?
No.
Can I
It is only for a member. It is a member's right. Outsider has no right. A society which gives a loan to its members or a society class of society which the state government may notify in the official gazette from time to time shall furnish each of the members with a passbook which shall contain an account of the transaction with the members, such as the date of transaction, amount of loan advanced, the rate of interest, the payment made by the member, the amount of the principal interest due, and such other particulars as may be prescribed. The necessary entries shall be made in the passbook from time to time, which shall be countersigned by such office bearer of the society as may be authorized in this behalf by the committee. For this purpose, the members shall be bound to present the passbook to such office bearer, and if the passbook is required to be kept for some time for making the necessary entries, the same may be kept. The member shall be granted a receipt thereof by such office bearer. Okay? This is a issue of passbook. The entries in the passbook duly made shall, until the contrary be proved, be prima facie evidence of the account of transaction of the society with the member. Okay? 33. Liability of a past member and estate of the deceased member. What we will do is section 33 onwards. Okay, now maybe 2 more sections are there, we will deal with it. Liability of a past member and estate of a deceased member. Subject to the principle of subsection 2, the liability of the past member or the estate of a deceased member or the society for the debt of the society as they stood. In the case of past member, on the date on which he ceased to be the member. So the moment he ceased to be the member, whatever the liability is crystallized, that will be there. In the case of a deceased member, on the date of his death. In the case of a past member, on the date on which he ceases to be the member, because he has resigned or he has transferred his shares. So the day he ceased to be the member, as per section 25 we have seen. Okay, so the dues gets crystallized. In the case of a deceased member, on his death shall continue for a period of 2 years from such date. Okay, for a deceased member for a period of 2 years. And in the case of past member, it is the day he ceased to be the member. Subject to the provisions of subsection 2, which we will see a little later. Okay. the liability of a past member or the estate of a deceased member of the society for the debts of the society, for the debts of the society shall society as they stood in the case of past member on the day he deceased or he ceased to be the member. In the case of a deceased member, it shall continue for a period of 2 years. Where a society is ordered to be wound up under any provisions of this act, the liability of the past member or of the estate of a deceased member who ceased to be the member or died within 2 years immediately preceding the date of the order of winding up shall continue until the entire liquidation proceedings are completed. That means in the case of liquidation, the debt will continue for a period, but such liability shall extend only to the debts of the society as they stood on the date of his ceasing to be the member or death as the case may be. Yes, you have a question?
हां, there is a confusion म्हणजे 2 वर्षापर्यंत फक्त तो आहे जिवंत तोपर्यंतच 2 वर्षाच्या नंतर नाही ऍप्लिकेबल असं.
Yeah, see.
So does this section means that if a person is deceased and there is outstanding with the society, so after a period of 2 years that outstanding will be waived off?
No, it is not so. Subject to the provision of subsection 2, this is regarding winding up. Leave that aside. Okay. The liability of the past member or of the estate of a deceased member. Okay. Liability of the past member or of the estate of the deceased member of a society for the debts of the society as they stood for the debts of the society. Subject to the provision of subsection 2, the liability of a past member, okay, or the estate of a deceased member of a society for a debts of the society as they stood in the case of past member on the date of which he ceased to be the member.
Yes.
So debts becomes crystallized.
Okay.
The amount becomes, let us say, I am just giving an example, there is something is receivable, the liability of the past member, okay, or of the estate. So something is to be received from that member. You are right. That gets frozen here. The moment he ceased to be the member, that means his liability gets crystallized and it stops. It is there, but it gets stopped.
Yes.
That can be recovered. That is a later part. What is to be recovered, who will pay, all that is later part. But his liability gets crystallized. Let us assume I am a member in a housing society. We will talk about housing society. Okay? I am a member in a housing society. Now, because I am a member in the housing society, I have to pay the maintenance. The day I have resigned from the membership and my membership has been accepted, that is the day where my maintenance gets stopped. But somebody else may occupy that flat, society may occupy the flat, whoever occupies they will pay. But my liability also has to be paid. That is crystallized then and there. But that liability will be recovered by the society. But it will be to the new member, because new member will be either admitted. Till new member is admitted, that liability will remain with the society. Are you with me now?
Yes.
Same way, in the case of a deceased member, suppose nobody comes forward, then I continue to charge the maintenance for a period of 2 years. But thereafter, I will charge billing to the who? To the legal heirs. So who is occupying the flat?
Okay. Occupant can be charged. Yes.
Okay, well, we can. Just look at section 33, whether that is applicable to housing society or not.
No,
This is not applicable.
33 is not available.
Not applicable. All membership clauses have been removed. Okay.
But sir, this means that charging of maintenance will continue for 2 years. It doesn't mean that it will be waived after that.
No, it cannot. It cannot be waived. It will not be waived.
It cannot be available.
It will be charged to the legal heirs. ठीक है?
Which means opinion दिया था ना मुझकी waive हो जाएगा.
Because society is charging interest on the
Yeah, they can.
thing.
Why not?
Even though 2 years period has been.
Yeah, they can charge the interest.
But which means opinion दिया था.
Anyhow, 33 is not applicable to housing society. Now let us not get into the.
Cases which are prior to 2019 will be.
Definitely. They are applicable. Where a society is ordered to be wound up, that we have already discussed. If it is a wound up, then the liability will continue till it is wound up. 34. Insolvency of a member. Notwithstanding anything contained in the Presidency Towns Insolvency Act, the Provincial Insolvency Act 1920 or any corresponding law for the time being in force, the dues of the society for a member in insolvency proceeding against him shall rank in order of priority next to the dues payable by him to the government or to the local. That means we get the priority.
Yes.
In that particular person is insolvent, then we get the priority. Last is expulsion of a member. A society may, by resolution passed by majority of not less than 3/4 of the members entitled to vote, who are present at the general body meeting for the purpose, expel a member for acts which are detrimental to the interest or working of the society. One is most important. If you want to expel the member, you have to pass a resolution in the general body where 3/4 of the members present in that meeting should pass a resolution, and that too if his actions are detrimental to the interest or not, or for the working of the proper working of the society. If it is against the interest of the society or working of the society, in then only we can expel him from the membership. Provided that no resolution shall be valid unless the member concerned is given an opportunity of representing his case to the general body, and no resolution shall be effective unless it is approved by the registrar. That means one, he should be given an opportunity to come in the general body. If he is not coming and giving his say, in that case also the resolution should be approved by the registrar. That means unless until the registrar approves, it will not happen. No member of society has ceased to be expelled under the foregoing subsection shall be eligible for the readmission as a member of that society or for admission as a member of any other society for a period of 1 year from the date of such action. For a period of 1 year from the date of expulsion, he cannot become a member of the same society or any other society, provided that the registrar may, on an application by the society and the special circumstance, sanction the readmission or admission within such period of any such member as a member of the said society or of any other society as the case may be.
So here it is given for admission of same society or any other society.
Correct.
So how would the other society know that he has been expelled from the previous society?
See, you are right. If the society does not know and he does not give that affidavit that I have been expelled from other society, nothing can be done. But otherwise, the admission form itself says that I have not become a member in another society, neither I have been expelled from there. So that, because say in a case of a credit society in the same area, there can be 2, 3, 4 credit societies. So one person may be expelled from one credit society, he may become member in another credit society. So for a period of 1 year, he should not become, provided he discloses. If he does not disclose, we will not know. Okay. So we are not God. Provided that the registrar may on an application by the society and in a special sanction, okay, readmission for a period less than that. So this is all about expulsion of the member. So with this section, chapter 3 we have completed, and you may have certain questions related to that. We will see later. Any question? है क्या? Yeah.
So एक सेम होता
Chapter 20, para 27.
हाँ.
The word society is used. It would be okay to write jurisdictional person, because otherwise the interpretation of statute may create problem.
I agree.
Because the trust also can come and HUF also can be included, company also could be.
Yeah.
So we will be taking chapter 13 separately for this.
Yeah. That is 13B is separate. Huh?
Okay. So 33 and 34, those sections which were not applicable to housing society, are they applicable to premises societies?
No, premises society and housing society are now considered as a housing society. If you look at the classification of a society, all premises societies are now classified as a housing society.
All premises societies.
13B, it says it is applicable to whom? It is applicable to housing society, tenants co-partnership society, tenant ownership society, premises society.
Other societies, about
Other society including premises society. It is written other society including premises society. You see it later. Okay, next.
So my question is, if one of the flat is sold by developer to two purchasers at the same time, and both of them make an application to the society for membership, the society accepts any one of it and grants them the membership to the society, receiving claim from the other member also, other person also. Then one of the member who is not admitted files a court case, and then he wins after a period of 10 years. Since last 10 years, the person who has been admitted is occupying that particular flat is been admitted as a member of a society. Now the court case comes that this person is not a member and he does not have the right in the flat. The another person, he is the owner of the flat. His agreement prevails. So in that case, when that person is when he goes to society for membership, so at that time whether the society can demand a premium of 25,000 from him for being a member, and also for last 10 years that person has not paid the dues of the society. So now whether that dues can be recovered from the new member, new person who is now being put up the papers for membership.
Okay, first of all, if the flat was occupied by the earlier member, okay, who has been, as per the court order, he has been admitted wrongly.
Wrongly, correct.
But if he is not paying the maintenance and still he was occupying because of the litigation, and the society has been maintaining that property, okay, so the dues of the society is recoverable. So the new member will have to pay the dues because the property has been managed, maintained by the society. Who is occupying is immaterial, but the property for the last 10 years during the litigation period also there is a security provided, there is a common electricity provided, the maintenance of the building is taken care, nobody was stopping there. So it is because of the litigation, their own wrongdoings. So that the maintenance, if that was not paid by the earlier member, the new member has to pay. As far as transfer fee is concerned, absolutely it is not required because there is nothing which is happening because of the compulsion by both the parties. It is because of the provisions of the order, because of the court order. So therefore there is no transfer fee.
Transfer fee is not required.
Absolutely not required because he is considered as a first member.
First member.
ठीक है? Okay. So next we'll deal with the next chapter. Let us see. Maybe we'll take up the appeal. Next time we'll take up the appeal and revision.
So one more thing is when we go for the transfer forms, 34, 35 and 38, there's lot of confusion because 38 is for transfer to become a member of a society and those two are for provisional members. Now if the person is expired and the legal rights are becoming a member of a flat by virtue of release date or any other document. So at that time, can we directly give the forms of 38 or is the provisional membership compulsory, mandatory?
No, provisional membership is not compulsory. He can be directly made as a member.
Sir, but how can that take place? Because when you talk about 38...
No, we'll do one thing. So next time what we'll do is we'll take up the transfers.
Yes.
In the case of a cooperative society. Huh?
Procedure
So
of
now that we have dealt with the general, next time we'll talk about the housing society.
Yes.
Becoming a member of a housing society and transfer of membership.
Transfer.
And then relevant provisions in the bylaws.
Yeah.
ठीक है. Okay. Thank you.